So what is a paralegal? The American Bar Association has a definition for paralegals. It has several parts. First of all, a paralegal is someone who is qualified by education, training, or work experience. So there's a number of ways a person can become a paralegal and learn how to do the task of a paralegal. The next part of the definition is a paralegal is retained by a lawyer or a law office or a corporation. That would be a corporation law office. Those are called in-house counsel, or by government, or by other entities like maybe charitable groups, labor organizations, and so forth. Then probably the heart of what a paralegal is this last part. Paralegal is someone who is performing substantive, specific, delegated, substantive legal work. And notice that I've emphasized this word, delegated, because the lawyer is going to be responsible. The paralegal can only do those things that the lawyer instructs the paralegal to do. So what are the tasks that a paralegal would typically do? Well, this, of course, is going to depend on the type of setting, the office, the type of business that the office is engaged in. And even then, that depends a lot on the lawyer that is supervising the paralegal. Paralegals, we are information people. That means we gather information, we process information, and then we report and organize that information. And so at the top of the list is gathering information. Paralegals will gather and organize factual information, lots of records. Sometimes it's doing internet research. Paralegals will also draft legal documents for lawyers. Now, it will be the lawyer that gives the instructions to the paralegal what goes in those documents, what those documents need to be doing. But paralegals are frequently involved with drafting legal documents for the attorney. Sometimes paralegals will conduct legal research. Once again, this will depend on the office, the particular office that the paralegal is working in. Many lawyers prefer to do their own legal research. Other paralegals would be highly accomplished so that the lawyer would be comfortable in having the paralegal do that legal research. Paralegals need to know how to do legal research in any event. Paralegals frequently assist at hearings and depositions and trials. It's always handy for an attorney to have another set of eyes and ears and hands at trial to assist him or her in the presentation of a case, to handle the documents, to keep track of the testimony and the exhibits and what's been admitted and what hadn't been admitted. And then sometimes even just babysitting the client or a witness. So it's not unusual at all for a paralegal to go to court or to a deposition with their attorney. Paralegals frequently have the responsibility for overseeing the scheduling of the events in the law office. Hearings, depositions, client appointments, deadlines, all of those things have to be kept track of. More on that later. And it's frequently the paralegal that's going to be doing that rather than the attorney. And then, of course, finally, the paralegal is a vital communication link between the attorney and the client and others. That's a lot of what paralegals are doing, is gathering information from others, reporting information back to others. UPL, Unauthorized Practice of Law, something very, very important for all paralegals to have an understanding of. What are the things that a paralegal may not do? Well, a paralegal may not provide legal services directly to the public without attorney supervision. This gets back to that part of the ABA definition that speaks about specifically delegated tasks that are supervised by the attorney. A paralegal may not give legal advice. That's practicing law without a license. A paralegal may pass on information that the attorney has given, but that information, that advice is the attorney's advice, not the paralegal's advice. So the paralegal on his or her own may not give legal advice. That's unauthorized practice of law. Thirdly, a paralegal may not represent a client in court or in front of what we call a tribunal. Frequently, these might even be administrative hearings. A paralegal may not do that unless they're specifically authorized by law to do so. And there are several instances where paralegals are authorized to speak for and represent a client before some of these tribunals. Primarily, it's going to be administrative hearing officers and things like that. But once again, it depends on the law, whether it's the federal law or a state law involved. Otherwise, a paralegal is engaging in UPL. You can't do this unless you're authorized by law. And then the fourth thing I have up here is that a paralegal cannot set a fee. It's just not a matter of setting a fee, but it's also accepting a case for the firm. Now, a paralegal can give information off of a set fee schedule. If the lawyer says, if someone calls in and wants to know how much I charge for an uncontested divorce with no children, no property, you can tell them this is what my fee would be. All right, that's all right. But because once again, that's coming from the attorney, not the paralegal. So the paralegal cannot set a fee. If the attorney is out of the office for an extended period of time and the client calls up and says, I'm up at the hospital with my loved one and we need a will done right away. Well, paralegals can prepare wills if the paralegal has been properly trained to do that. But a paralegal on her own or his own cannot say to the person, yeah, I'll come right up to the hospital and we'll fix you up, because that's the paralegal accepting that business. Only the attorney can do that. So the paralegal cannot accept a case or set a fee. So, well, what can a paralegal do? Everything else, if the task has been delegated by the attorney and if the attorney is supervising. That's assuming that whatever the paralegal's been asked to do, told to do, is legal in the first place. But a paralegal may do everything else as long as there's supervision and it's delegated. Ethical responsibilities. Paralegals have ethical responsibilities just as attorneys, and in fact, our responsibilities as paralegals are going to be pretty much the same as the attorneys. Paralegals cannot get disbarred, attorneys can, but with what a paralegal does that's improper or fails to do, there can be bad consequences for the attorney, some sort of sanction, or maybe even disbarment if the attorney has not been properly supervising that paralegal or did not properly train that paralegal on the limits of what a paralegal can do. In fact, I have a saying, it's paraphrasing something from one of Clint Eastwood's movies, a good paralegal has to know his or her limitations. And that's what ethical responsibilities are all about. Paralegals have pretty much the same duties and responsibilities, standards that attorneys do. Each state has its own ethical standards for attorneys. And many of those are based on the American Bar Association's model rules for professional conduct. These rules may differ slightly from state to state, but they're all pretty much the same. And paralegal associations also have very, very similar rules for their own members that are, I won't say modeled after, but are pretty much the same as what the attorney rules are. And those rules have a lot of commonalities. First of which is confidentiality. This is the heart of the law office. The attorney the paralegal has to maintain the confidences and secrets of a client just as an attorney does. Paralegal has to be honest with all people that the paralegal deals with, whether it's the court, other attorneys, certainly clients, honesty in all dealings. We must be mindful of any conflicts of interest that may arise between the paralegal and the client's matter. Loyalty at all times to the client. That means the paralegal can't be engaged in any business that would be adverse to the client. The paralegal may have worked at a law firm that represented the client's spouse, ex-spouse, or some other party that is now adverse to the client. And now the paralegal finds himself or herself at a different law firm now representing the client and perhaps having adverse information. So anything like that you need to bring immediately to the supervising attorney's attention. So we have to avoid every step of the way conflicts of interest. Then malpractice. Malpractice is really not an ethical matter other than that we're not careful. We have to avoid malpractice. We must avoid carelessness in everything we do. And that means attention to detail. Paralegals are detail people. That means if we don't know something, then we ask. Don't ever guess. Always ask. Ask another paralegal. Ask your supervising attorney. If your supervising attorney is not available and there's another attorney in the office, ask that person. Always ask. Never assume. And then the other part of avoiding carelessness is using systems. Law office will have a number of systems in place that help us do things at a routine, thoughtful process. And those systems will be regarding the filing of our client papers or the docketing of events that we need to be aware of, court hearings, deadlines, client conferences, depositions. And then, of course, using systems for communications. One of the things that deals with confidentiality is, well, what about the role of advanced and changing technologies now in keeping our clients' secrets safe? We have to be aware of that and use systems that protect that. And so this, in a nutshell, is what a paralegal is.